Oh, hi everyone. So, I'm going to be looking at the kind of differences between the changes and amendments to the ACTA loan out agreement. And I'm not going to go through them all because there are three versions. We've already looked at, you know, the agreements as standalones. So what I'm going to do, I just want to look at the comments from Lindsay Strasberg, who is Libraries Counsel, and Joseph Lanius, who is Wayfarers Counsel, and just see, focus on them. There will be other amendments in there, will be like minor changes to wording, etc. I'm not going to go through that. It's just specifically where there are comments or I mean, there's a couple of additions that Lively tried to add, which I found quite interesting. So we'll have a look at them. But I just want to get through these quite quickly. But I do also want to say a big thank you to docketupdates.com for the incredible work they do. And the brilliant resource they have established. So it's made certainly my life a lot easier for things that aren't available on the docket. That and it's really organised as well. Actually, I appreciate that. It's so well done. So big thank you to them and to Bocce for all the hard work that they do, and to Clark as well for getting these documents. It's wonderful when a community comes together. So I won't read the emails here because it just goes back and forth. Okay, so this is the first comment. So we know this is Lindsay Strasberg because it's got her initials, LS, and then it's 1 because they number the comments. In the blue, which is Wayfarer, we know it's Wayfarer because that's the initials there are JL for Joseph Lanius. Okay, so she wants to remove this clause here, which is execution of agreement, company's receipt of executed copies of this agreement signed by lender and artist. Strasberg is saying, well, the company has effectively waived this condition in practice, right? So I'm not going to say much about that because on the next version, Wayfarer, this is how this works. They make notes. They strike some stuff out. They put a comment as to why or what their reasoning is for that, and then they send it to Wayfarer. Wayfarer will either approve or they will, do their own strikeout and then put their own comment and say, no, we don't agree to this. Or can you explain? Like, this doesn't make sense. And we'll see that. And then we get to the end result then. So that's why I'm just doing the comments. So she wants this removed. She's basically saying, you've waived your right to request the company's, you've waived your right to receive executed copies of this agreement. In that, so the condition was they have to be signed by Lively and the lender, which is Blakely Inc., for the agreement to be executed. And Strasberg is saying, well, no, you've already waived that condition. So we will see Wayfarer's response if there is one. Loan out documentation inducement. Okay. So she's removing the second part of this, the second requirement, which is that the inducement attached hereto and incorporated herein by this reference fully executed by lender and artist. So again, she's just removing any references to this being executed by something that the lender and or artist has to do. Strasberg says, of course, this is part of signing a long form, but it's not a condition precedent to your obligations at this point. Okay. So they're haggling here over the release of the film. Lively says, she's added terminology which company acknowledges and agrees will be a wide theatrical release and which promotional services may include, etc. So Wayfarer are saying, look, we're confirming it will be a wide theatrical release, but we cannot include that language contractually. And Lively is saying, well, this was a deal term. So she's adding in that language. I think that there's a line at the bottom there which she's removing because it's duplication. Okay. Compensation. This is about offsetting damages. Upon the condition that lender and artist are not terminated for default, subject to company's rights of suspension and or termination on account of lender and artist default for disability, or an event of force majeure, as such terms are defined in the standard terms attached hereto. And then Lively has removed the wording and company's rights of offset for damages caused by lenders and or artists default. And then it was supposed to then say company shall pay lender as full and complete consideration, etc., etc. Lively has removed the offset part of the clause. She says it's not customary language. There is no automatic right of offset, so they can't offset damages for any event that is caused by Lively being terminated. So then they're just talking about, how they're going to work out the tax withholding for the 2 days in LA. She asked about whether they Wayfarer confirmed that New Jersey tax will be at this rate, and Strasbourg is saying, well, does that apply to the 2 LA days? So we'll have to see what they respond with. So this is about advertising overhead. Because of it being reduced to 5%. Wayfarer say this must remain, but Lively saying no, it's supposed to be Sony's A+ pool definition. We are holding on no advertising overheads. Okay. So this is in the event, and it did not happen, that Lively wins an Academy Award. Lively says we never discussed the bonuses being cumulative. Wayfarers respond with this is required and quite standard. Lively says we disagree and was not the deal we made. And they've changed the accommodations and everything, like to be in Los Angeles, but they've taken out Las Vegas. I don't understand why, because this doesn't read right to me. So accommodations, while artist is on location in Los Angeles, right? So they've added on location in Los Angeles, rendering services at Las Vegas, Nevada, because that didn't happen. They didn't shoot anything in Nevada. I don't know why the strikeout did not just end there, because you're reading straight from reading like this. Okay, so while artist is on location in Los Angeles, one mutually approved, and it's like that doesn't make sense. What is happening here? Who's doing what? But they've struck out the word in company shall furnish artists with the following, and I think they shouldn't have done that. They should have left that there. But we may see that coming back in. Interesting that she, for the per diem, she wants per diem for herself and companions is what she's added. She's increased her per diem from $100 to $150 per day for herself, but she also wants $90 per day for her assistant, her nannies, and her security personnel for the time that she's traveling to Los Angeles. That's just extraordinary. Artist credit. Upon the condition that the artist appears recognizably in the role for the picture as released to the general public. She has removed, and provided that neither lender nor artist are terminated for default hereunder, including without limitation the morality clause as set forth in the standard terms. So she is saying, well, no, you are going to give me an artist credit if I appear recognizably in this picture when it's released to the general public. And she's changing the wording to include if she is terminated. So there's the executive producer credit. We know that changes. I'm not going to go into too much detail. I'm not going to go into detail here, right? Basically, the changes here proposed expand quite exponentially her rights of approval over anything that contains her name, her likeness, and her voice. This is something that doesn't actually surprise me. Her contract, her endorsement agreement with Family Hive for her hair care products, she had so much control, like near total control, actually. It was above and beyond what is standard. So that this does not surprise me that all this control is being kind of clawed back by Lively here. Again, we'll see how Wayfarer responds to this. So this is quite standard. It's like so in blue. Just to summarize it, what Wayfarer are saying is, look, we agreed to, you shall have approval over X, Y, and Z. However, we would like to be able to have the right to use in co-promotions without any further compensation to the lender the artist name solely as it appears in the billing block and or in conjunction with the artwork title of the picture. Artist name as it appears with a list of the principal cast. Now, some of that she has agreed to because she hasn't done a strikeout. But then there's the rest. And or in synopsis of the picture, likeness as it appears in the key art one sheet for the picture, solely during these periods when company is advertising and or promoting the picture in conjunction with the theatrical and or home video release of the picture, artist voice and likeness as they appear in company's trailers and or TV spots for the picture. And the list goes on, and she has struck all of that out. Wayfarer said, we need this to remain. Lively says it's inconsistent with the deal terms. She has approval over the use of her name, voice, and likeness in merch and tie-ins, and we did not agree to a list of exceptions. That being said, we will allow certain limited carve-outs here. Now, here they're not talking about anything new. They're talking about what she's already shot and what will already form part of the film and the trailer. That's it. But she is still wanting to retain complete control over all of that. I mean, I find that baffling, I think. I'm not saying that this is an unusual situation. I'm sure there are some, Hollywood stars who kind of command these kind of terms. People like Tom Cruise. I'm sure Ryan Reynolds does. But but this is stuff. This is the part that she's already been paid for. Do you know what I mean? And like, when do you go pay for a service and then that person, or pay for a good, for instance, like, you buy a pair of trainers, right? And you pay for them. You take your trainers. You don't then have the shop telling you how to wear them, what feet to put them on, when you can wear them. You're not allowed to walk through mud in them. So it's just it's bizarre to me anyway. It may be perfectly normal in this world, but this world is bizarre to me. Also, she removed any use of clips or excerpts of artists in any other audiovisual productions, including without limitation, prequels, sequels, and/or remakes, shall be subject to artist's prior written consent on a case-by-case basis. And the wording that was there was, except with respect to any sequel of the picture, we know that there was due to be a sequel, and she has removed that. And the note says, not agreed, sequel use requires approval and separate negotiation. Okay, so okay. So Lively's adding this. In addition, artists shall have approval of references to artists in any additional press releases, statements that discuss artists being mentioned as an actor in the picture. Okay. Strasbourg says this is a specifically negotiated point from the deal terms. Artists will have approval of product placements / integrations to the extent artist is required to reference, handle, or otherwise interact with the product. We do know that Justin Baldoni's dad was overseeing product placement in the film. I think the only thing that come up that was like there was some kind of sponsorship deal or something with Guinness. Now, this is what ex-patriarch is alleging at the moment. And he's saying, oh, look at the hypocrites, blah, blah, blah. They're advertising alcohol, so why can't Lively? Now, when you're doing a bar scene, haven't you, because you've got to, if you use a drink or product in there that has as brand, much like Lively's contractual rights for approval here, they may be, you have to pay some kind of compensation. You have to seek permission to use said brand. So that is not the same. It is such a stretch to try and compare using an alcoholic drink as product placement in a bar scene where, when you try to compare that to what Lively was doing, which was literally promos and trailers with just non-stop, drink this alcoholic drink my drinks, and even naming drinks after characters, including the purported abuser. So it's like, what are you're not even comparing the same thing. What else were they going to drink at the bar? How would that look realistic if they'd been drinking, anything else pretty much? And if they used anything else, they would have had to have some kind of product placement anyway. They would have had to have, some kind of deal made, even if they were standing there with a can of Coke. So Strasbourg again says that the product placement approval specifically negotiated in the deal terms. Okay. So I don't think there's anything interesting here. Termination rights of the parties. Wayfarer says cannot make the changes requested here. What's part 4? Library says holding on to previous comments to paragraph 4. Okay. Now, this is an odd clause to try to insert in here. And this is something I did want to come and talk about. So, the terms she's trying to change here, right? Sexual harassment clause. Sexual harassment of any type is strictly prohibited and cause for immediate termination of this agreement by company, right? She's trying to add in that she can also terminate in the event of sexual harassment. That part in itself, I don't think is entirely unreasonable, because as long as it's pertaining to the agreement, that it affects her materially, because this is a contract between her and Wayfarer, or Blake Link and Ainsworth's movie. It is not regarding any other cast, crew, no one else. No one else is subject or party to this. But at the bottom, nonetheless, and I think this is just wild. She does try to insert this paragraph, right? So Wayfarer, at the end of the paragraph before the red lines, in the event the company is made aware of any sexual harassment conducted by artist, company shall have the right to immediately terminate this agreement and available to all rights and remedies hereunder. But she wants to also add in a paragraph that says, in the event artist is aware of any sexual harassment conducted by company, then lender and or artist shall have the right to terminate the agreement and remain entitled to full compensation and have the right to avail themselves of all rights and remedies hereunder and under applicable law. Now, she's basically saying, well, if I become aware that someone in the company sexually harasses, it doesn't even have to be her. It could be literally anyone, right? Then she wants to be able to terminate her agreement and invoke, her rights to compensation and any other rights and remedies. And even if it doesn't affect her. And that's just nuts to me. Why? Why should Wayfarer agree to that? If it doesn't affect you, then why? Because I mean, she can't be concerned about someone in the company potentially sexually harassing someone other than herself, right? And say, well, that's it. I cannot tolerate this. I cannot work with this person. This person has spoken very highly of and worked with people like Harvey Weinstein, Woody Allen. Like, so the mere fact that, and I'm not condoning this, I'm just from the perspective of how she's trying to reword this clause in the contract. So it now, in this case, she is saying, well, if someone from the company sexually harassed um anyone else, even if it's not me, I'm going to be so offended that I want rights to terminate this agreement. She had no problem being on good terms with known sexual abusers, harassers. But this is a completely insane kind of addition that she's trying to make, for want of a better word, because she is seeking like quite extensive rights for something that doesn't even have to have any effect on her at all. It does not have to cause her any harm, any loss. She doesn't have to suffer a thing, but she still wants the rights of someone who is harmed and does suffer losses. Sorry, I'm just seeing if there's any more. It doesn't appear to be. No. Okay, so let's go to. Oh, right. Let's go to the next one. So that was the February 4th agreement. Okay, so this is the March the 7th. Oh yeah, she needs a full-size SUV rental car while she's on location in Los Angeles and wants reimbursement of the costs. They do agree to it, but for shoot days, but not extended days such as the weekend. Yeah, okay. All right. So let's see some of the responses. So Wayfarer have pushed back on the removal of the execution of agreement clause. So I'm not going to read the comments that were already there. I'll just go through the new ones. All right. And Wayfarer respond, it still needs to be left in, as is always in a CP conditions precedent in every deal I've ever done. Also, the loan out documentation inducement. They have rejected that change. And Lanius is saying, well, yes, having a signed agreement along with all exhibits is always a condition precedent. Wayfarer saying that that she has an obligation to make personal appearances and engage with interviews. This and that wording's got to remain because it's customary for a lead in the film. Company acknowledges, provided that artists shall not be obligated to perform any particular promotional services, which lender and artist find personally offensive, provided that lender and artist use good faith efforts to perform other comparable promotional services. And Wayfarer is saying, well, because I think Strasbourg tried to take it out and says, well, it already says this above. But Lanius is saying, well, no, it must remain. Part of her fee is for her to perform promotional services. This should come as no surprise as she is lead. So a bit of snark. I won't go into that too much. So this is her request for Leslie Sloan to be, to get all of this costs for travel expenses, etc. And they've said no. They've discussed it with Sony. They are not going to. There's certain things they're not going to agree to, which includes travel and expenses, if applicable, for the hair and makeup stylist. They're not going to agree to the wardrobe budget and reimbursement. They will agree to her designated security personnel, which may be up to 2 individuals. They're not going to agree to anything for the assistant, and if requested by artist publicist. So they've said no to that. We'll see how that holds out. But I mean, I think that was just what necessity does your fair enough, you need an assistant, fair enough, you have kids, especially a newborn as well, you might need the help of nannies, fair enough, you are well known and married to an A-list actor, you might need security, and I think we can concede some of that. But do you need your publicist to be with you when you are filming a movie? No, And if you do, should that not come out of your own pocket? Why should the studio pay for that? What benefit is it to them? I mean, I'm sure there probably is some benefit, but that's not the point. You know, why should they pay for your flipping publicist? Okay. Uh, so the compensation, they Wayfarer did concede on that. So they will still pay her full and complete consideration for her services and all rights, even if she is terminated. They've sorted out the tax withholding as well for the 2 LA days. Wayfarer said yes, it was already deducted when it went into escrow per the fully executed escrow agreement. And I feel like I was a bit of a dig then, the fully executed. um, okay. Yeah, so they wouldn't cave in on the advertising overheads either. They said it must remain the same for all. So there we go. They said no. Direct accounting, payment, and audit rights from Sony per deal terms. Wayfarer say the rider already says participant will get statements directly and has accounting/audit provisions. Okay. So the bonuses, yeah, for acting awards. Wayfarer say because Wayfarer's so Lively's position was we never discussed the bonuses being cumulative. Wayfarer says, well, this was required and it's quite standard. Lively says we disagree and was not the deal we made. Wayfarer quite fairly come back and say, well, it was not expressly laid out either way. So I can say it's not the deal we made either. However, in good faith and in order to close, we will give. So they caved on that point. They've added a rental car in here. While in Los Angeles, for artist shooting days, one full-size SUV rental car, fully insured and including reimbursement of expenses for reasonable gas and parking upon submission of actual receipts, which artists shall use to self-drive to and from set, provided artists shall be responsible for any parking tickets, traffic violations, uninsured damages, and tow impound fees. So, the artist credit. So obviously Lively wanted to have the artist credit whether or not she was terminated. They say standard actor condition in his appearance in the role as released. Wayfarer says no, disagree. Completely standard these days to have credit removed for a breach of the morality clause. So they agreed to the name and likeness request, and they confirm for the avoidance of doubt, lender and artist shall have no right to approve any trailers or promotional films if using the now existing footage from the picture. Which is what I said. Why would you have rights of? You already had right of approval over the footage when you when you shot the footage. So why would you now get to have right of approval over the same footage and basically tell the company how they may use it in terms of promotional stuff, trailers, etc. When it's existing footage, you've already been paid for it. You already had your right of approval over it. Okay. So they didn't comment on the use of her likeness for sequels. This is going to annoy me. It did annoy me. It will annoy you. There's a whole clause. Bearing in mind, she wanted a rental car. They said, okay. She wanted certain approval rights. They said, okay. Eventually, she wanted a producer credit, not an executive producer credit. And they said, okay. What they wanted was the copy table book. And what the clause basically says is, right, so notwithstanding anything to the contrary, contained herein, artist acknowledged and agrees that one company is creating and publishing a copy table book. Right, and we've seen and read about this book in other areas. Colleen Hoover approved it initially and then suddenly didn't approve it, and it was pulled. And I think when we see the next version of this, we'll see why. So, company is creating and publishing a copy table book in connection with the picture. And two, the company may use artist name and likeness limited to any approved stills. So these are already approved stills. Otherwise, artists shall have the right to approve any other images used by the company in the copy table book without any approvals required and or additional compensation payable to the lender or artist except for a royalty of 1% of net merchandising proceeds related to the copy table book. Net merchandising proceeds shall mean the amount of gross receipts actually received by company in connection with the exploitation of the copy table book, less a deduction of 50% of such gross receipts for company's distribution costs, fees, expenses, but no other deduction shall be made other than said 50% deduction to calculate the net merchandising proceeds. The royalty amount for the copy table book should be no less favorable than the royalty amount for all cast members, and the calculation and definition for net merchandising proceeds shall be no less favorable than the same for all cast members. So they're putting in a request that she is, agrees to this copy table book. Is in, and when I say agree, I mean there's no right of approval over already approved stills, but anything else she has right of approvals over, and she will be entitled to, a royalty amount that will be no less favorable than any other member of cast. We'll see how Lively treats that. They agreed to this. Artists shall have approval references to artists in any additional press releases, statements, etc., that discuss artists beyond being mentioned as an actor in the picture. So Wayfarer agreed to that. Okay, so where she wanted the approval of any product placement, Wayfarer said no. They struck that. This is interesting. The premiere. A company shall invite artist and one guest to all US celebrity premiere of the picture. And company shall use good faith efforts to have the distributor provide artists with transportation expenses and personnel. Did you see how many guests she had? She had a family. She had Hugh Jackman. She had Ryan Reynolds' mother. Far more than one guest. I think the only bit here is I want to know what they do with the sexual harassment clause that she tried to insert. Okay. Yeah, so they took it out. He says this is not acceptable. There can be no instances where there is a right to terminate the agreement or have a right of injunctive relief. So this is confidentiality. And he's taken out, nothing herein shall prevent any party from making truthful statements about their participation in the production or in connection with any exercise of their legal rights hereunder or under any other agreement in connection with the production. So she's trying to get in a clause that says nothing's going to, I don't want there to be anything to prevent me from making a truthful statement about my experience in connection with the production. And Lanius comes back and says, I've literally never seen this language before. And this is opening a whole can of worms on a debate on what is actually truthful. The truth is quite often subjective and not objective. I love that. Because, even with Lively's chosen word in there, right, it does specify truthful statements, not just statements, truthful statements. It doesn't say subjectively truthful statements or, express opinions. And then you've got to test, well, what is truthful? And that, he's right, it does open up a can of worms. Because what she deems as truthful, Wayfarer may disagree with. And we are literally seeing that play out in this lawsuit. So he says no. I don't think there was anything else here. No. Okay. So this is the April 18th version. So they are now responding to those comments we just saw from Wayfarer. Wayfarer were responding to her comments. They do talk about, there's an email here, just out of curiosity. Yeah, they talk about, actually, I want to just quickly look at this. Sorry, I know I'm bouncing up and down. It's really hard because I'm not able to open this up as full page. Joseph Lanius. Where is it? Okay, yeah. So, hi, Joseph and Amin. So this is actually Lindsay Strasberg, sorry. We are reviewing and discussing the revisions. In the meantime, I want to let you know that there has been no discussion of a coffee table book incorporating Blake Lively's name and photographs. So usage should not be considered approved by her. We are not sure on what basis it was included in your latest draft, reserving rights, Lindsay. And then Amin writes back, hi, Lindsay. Hope all is well with you. Yes, as part of our ongoing efforts to promote and enhance the visibility of the movie, we've successfully secured a partnership with Simon & Schuster, who are Colleen Hoover's publishers, to produce a companion piece featuring still shots from the film's production, accompanied by relevant text from Colleen's book. This strategy mirrors successful ventures undertaken by other notable films such as Hunger Games and Barbie. The book will showcase candid behind-the-scenes moments, including interactions with various production departments and glimpses of the actors on set. We believe this will offer fans an enticing insider's perspective that aligns with their interests. Given the necessity for Blake's approval of the featured photos and the time required to compile and finalize the book, we are operating within a tight timeline, so it's imperative that we expedite the execution, approval, and printing processes to ensure a timely release. To facilitate this, I am prepared to share the language provided by Simon and Schuster for the copy table book. Please rest assured the terms outlined are customary regarding participation. I think she must have tried to call her, and then so Lindsay Strasberg obviously tried to call Amin Miziam. She then writes, Lindsay, I just tried calling back. I was in a meeting when you called earlier. I know you've had a chance to speak with Joseph. Quite frankly, the omission of the copy table book in the agreement is my mistake. It wasn't intentional. There has been a lot of work and it slipped my mind when I reviewed the drafts. Please feel free to call me back when available. She gets a response. I mean, I appreciate your response, but this should not have been dealt with in the contract in the first instance. It's a significant ask that should have been discussed collaboratively with Blake and her team from both a creative and a business standpoint before ever getting to the point of putting language in the contract. I suggest that we reset and that someone from Wayfarer reach out to Blake's representatives with a proposal that includes full creative context and a meaningful financial participation. Then Emin then responds, Lindsay, thank you. We are preparing the offer and Wayfarer will send it to Blake's reps. Thank you. She then follows up a few days later, nearly 10 days later, actually. Hi, Lindsay. We received your email regarding the copybook. Thank you for the update. We really need to wrap up Blake's long form. Could we please have an ETA? And then she tries again on April the 1st. We really need to wrap up and complete delivery with Sony. And then another week later, could you please provide an update? This is the only agreement missing to complete legal delivery. Thanks. Okay, and then they're just arguing, like they're just sort of like, well, we're waiting for Sony. And then, Wayfarer saying, well, Sony let us know that they need to have the agreement executed in order to get back to you on the guarantee. So that's what they're talking about there, the guarantee. And then Joseph Lanius then writes, well, this is the final agreement to close out on this project. Everyone else is executed, so really hope we can get some movement this week, as I would like to close my books for this project and keep it moving. Okay, and then they send their comments to the agreement. So, sorry, I know I'm bouncing up and down here with the pages. It's challenging to navigate. Okay. Again, I'm just going to go through the responses. They do put in there again that the execution of the agreement and the loan out inducement, they try to say that the condition is hereby waived. Wayfarer technically did not agree to that. They also tried to put back in everything for Leslie Sloan. Oh, so the first class accommodation can now be mutually approved by artist. Pushback on the advertising overhead as well. Took out the reduced to 5%. Right, so they've agreed the award stuff. The rental car is now in. Lively actually agreed. She conceded on the artist credit. So if she appears recognizably in the film, but either her or the lender are terminated for default, then she does not get the credit. That obviously didn't happen, so Executive producer credit, in addition, artist election in her sole discretion, which election company will confirm with artist in writing prior to locking credits on the picture. She took out the coffee table book. Wouldn't agree to that. Put back in the product placement request that she has approval of product placements. Oh, let's see. Standard terms. She's put back in the sexual harassment clause. In the event artist is aware of any sexual harassment, she wants right to terminate, etc., etc. All that is back in. Looks like everything else. Oh, hold on, what's this? Confidentiality. So she's put back in that clause as well. Nothing shall prevent any party. Nothing shall prevent any party from making truthful statements about their participation in the production or in connection with any exercise of their legal rights hereunder. So she's, I think originally she wanted nothing will prevent artists, but at the moment it says nothing will prevent any party. I'm not sure if it did say. I'd have to go back to it. Okay. Okay, and now here is the May 5th version. Oh no, this is May 5th, 2023, isn't it? Okay, so we have seen this. So here is the April 29th version. So this is Wayfarer responding to the latest Lively version. So this is where the producer credit has now been changed from executive producer to producer credit. Okay. So to my knowledge, this is the latest version. As you can see quite clearly that when it comes to like Lively saying, well, they effectively waived their right to execution. Wayfarer have actually gone back and specifically said no to that in both the execution of agreement and the loan out documentation inducement. They've said no. They're not prepared to waive these conditions. Okay, so Wayfarer relented on the travel and expenses for the hair and makeup stylists. They would not budge on the wardrobe and reimbursement budget, and they absolutely would not budge on the publicist travel and expenses, and not just Leslie Sloan's, travel and expenses, but if she's not traveling with Lively, then it's any personnel that she needs to. They wouldn't agree to a private round trip air transportation for Lively. They did cave on the advertising overheads. They also added in, and I think this is good, where this clause initially was this paragraph kind of placed several responsibilities on Wayfarer as financiers. Wayfarer added in Columbia Pictures because Columbia Pictures were co-financiers. So why should it be just Wayfarer? Okay, they agreed to the artist credit, so yeah, they took out the language that is struck there, which is including without limitation the morality clause as set forth in the standard terms. But they did they agreed that she wouldn't get the credit if she was terminated. So here they've changed the executive producer credit to a producer credit. Copy table is still removed. And I believe this is what happened with Colleen Hoover as well. I think Blake Lively may have distorted facts. Oh, they told me that you know, they didn't tell me about this. They tried to sneak it into my contract without discussing it with me, blah, 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 blah. Completely distorted the facts when Amin Mezian has already said, that was my fault. It was an oversight on my part. Very sorry for that. Can we now agree it? And I think that Lively has probably leveraged this. And when Colleen Hoover refers to, she said something along the lines of, well, I was lied to. So, I withdrew my endorsement. And basically, I think that this clause in the contract was the catalyst for what went wrong with the copy table book and with Colleen Hoover's perspective of what happened there. Okay, so all that seems to have been agreed otherwise. They absolutely would not give her a right of termination in the event that the company sexually harassed anyone other than herself and she became aware of it, which I think is sensible. I can't believe she was actually trying to, exploit someone else's potential problem, theoretical problem, to her own use. I mean, when I say I can't believe it, of course I can believe it, but because she did it in other areas, like Isabella Farah's nudity rider. So so Wayfarer did not budge on it. I'm glad they did, because unless she has been directly affected, unless she has been harmed, and unless she has suffered a loss, she should not have a right of termination. Okay, I can't think of. Oh, hold on. Oh, yes, and the nothing shall prevent any party from making truthful statements about their participation in the production in connection with any exercise of their legal rights. This tells me that this was preempted. All of this, what's happened now with the lawsuit, with going public in the New York Times, the back and forth over this clause specifically makes me believe, and I don't think unreasonably, that there was preemption, that she was going to do this, that the New York Times, doing something, pulling off something like the New York Times article was there. Now, at the time of this, she wouldn't have known about, she hadn't heard from Stephanie Jones. She wouldn't have known about Jen Abel's phone. I think that was just an added bonus gift. But I think, the teeing up goes way back to having everything lined up, that if I don't get what I want, I'm going to go public. And it got to a point where she literally tried to get that written into her contract. Wayfarer said no. Okay, I don't think there's any. No, there's nothing else. Okay, so that was interesting to go through, see how that kind of evolved. Wayfarer conceded an awful lot. I maintain that you cannot look at these terms of agreement in these loan out agreements. You cannot look at the PGA letter that she wrote and come to the conclusion that she had no power and she was just merely an employee. You can't get to that conclusion, I don't think. If Lyman does, fine. I would want to see his reasoning for it before. I just don't think he can. All right. So I'm going to kind of leave that there. I will be still going through a bunch of stuff in amongst these filings here. I've also got I've still got some of the existing filings as well to get through, so I will continue with that. Thank you for watching as always, and I will be back soon with another one. Oh, and if you didn't catch me, I was on a live stream with Omar and Emmy from House of Chat last night. So if you didn't watch that, if you didn't catch us live, please do check out the on replay